Navigating family dynamics when planning for the future can feel like walking a tightrope, especially in blended families. You want to ensure everyone you love is cared for, but the legal landscape can sometimes feel complex and unfamiliar. What if your true intentions for your stepchildren are overlooked? The most direct way to prevent the disinheritance of stepchildren in a will is through explicit and intentional planning, primarily by clearly naming them as beneficiaries. Unlike biological or adopted children, stepchildren typically do not have an automatic legal right to inherit from a step-parent's estate without specific provisions. This crucial distinction exists because inheritance laws generally define children as direct descendants or those legally adopted into the family. Without adoption or explicit mention, stepchildren are often not considered legal heirs in the eyes of the law. This means that if a will simply states, "my children," or if there is no will at all, your stepchildren could be unintentionally excluded from inheriting, even if you considered them your own. To ensure your stepchildren are included, several practical steps can be taken. First, clearly name each stepchild in your last will and testament, specifying exactly what you wish for them to receive. Do not relying on general terms like "my children" or "my heirs." You can also consider establishing a revocable living trust, which allows you to outline detailed distribution plans for all your beneficiaries, including stepchildren, outside of the probate process. Furthermore, review and update beneficiary designations on assets like life insurance policies, retirement accounts such as a 401k or individual retirement accounts, and investment portfolios. These designations often supersede your will, making them vital for direct transfers to your stepchildren. An important concept to understand in estate planning is the difference between per stirpes and per capita distribution. Per stirpes means that if a named beneficiary passes away, their share then goes to their direct descendants. Per capita, on the other hand, means the inheritance is divided equally among the surviving named beneficiaries. For blended families, specifying per stirpes can be particularly helpful if you want your stepchild's children to inherit their share should your stepchild pass before you. Another key element is the residuary clause in your will. This clause dictates who receives any assets not specifically designated elsewhere. A carefully worded residuary clause ensures that remaining assets are distributed exactly as you intend, preventing any part of your estate from being unintentionally excluded from your stepchildren. By taking these deliberate steps, you gain peace of mind, knowing that your deeply held wishes for all your loved ones are legally protected. Thoughtful and clear estate planning ensures that your legacy genuinely reflects your love and commitment to every member of your blended family, providing security and care for their future.